All right, the recording's going, so we'll get started. Thanks everybody for coming into the first of our civil commitment performance standards work group. Um, I think the best place to get started today is going to be to do some general brainstorming on kind of what we want included in this. And I think we talked about last time, we've got a lot of leeway on where we go from here and where we end up because there aren't really model standards for us to pull from in a lot of this. So with two questions in mind, um, I'm going to be quiet and let you guys talk because civil commitment is one of the things that are really not my area of expertise. Um, but I think the two questions that I'd like everybody to keep in mind are number one, what does it take to be a good lawyer for someone in a civil commitment situation? And number two, what are some real things that OPDC can monitor as far as metrics go to look at compliance with whatever standards we set up? So hopefully that's at least a little clearer than mud. And uh, I'm going to turn it over to you guys to kind of brainstorm how we're going to do this. And then Kevin and I will put together something and we'll review it and we'll go from there.
Jordan, could I, something that I'm thinking about a lot that I think is relevant to this group in the legislative session, um, there's a couple of bills that relate to civil commitment, one of which would require courts to appoint lawyers at the time that the notice of mental illness is filed, um, which will, I don't think it's going to pass in this session. That was taken out of the omnibus bill and sent to Ways and Means because the fiscal on that is huge.
It's
But
so I don't know if you know, Allison, but it got moved to 2481 combined with the guardianships for aid and
yes,
assist.
yeah,
So,
and sent to Ways and Means, right?
okay.
Yeah. So I would be surprised if it passed out of this session, but there was a lot of momentum for that concept. So I think the money is just holding back. But I mean, I've heard from other practitioners that that is a best practice. I certainly think that that's a best practice, and that's something that we should be working towards. Even though that is going to require us to pretty dramatically expand the civil commitment workforce.
Yeah.
So that's not to say that I think the standards need to be high or appropriate, but I think we also
Mhm.
need to be thinking about how do we possibly extend the reach of who we are qualifying as civil commitment attorneys outside of just strictly criminal defense practitioners or strictly public defender offices, and thinking about how do we make the standards accessible for people who might not be in the criminal defense, the public defense community.
I agree. I think you've got a good point there. I also think that the result of that legislation will possibly shape the scope of what we're looking at here, because the performance standard, like if if it passes, everyone will be day zero. There are three counties, I think, right now that do it routinely, possibly more. But given that well, I don't know, maybe this is a question, since you're, if I'm remembering correctly, you're in a county that does not currently do day zero appointment, at least not routinely, whether the fact that you have those extra days during the investigation portion, um, how does that impact the standards that we want to move to? Because not everyone will have those 3 days if 2481 doesn't pass.
Yeah, I mean, we appoint on day 3 here.
Yeah.
I have been working with our county council, and I think our presiding judge will be on board with a request to start appointing us at day zero if we can manage the capacity of it. And
Right.
I think for us, I mean, and the other thing that's floating around is the NAMI bill that explicitly wants to move more people into the civil commitment system. So even if the appointment bill doesn't pass, then that is anticipated to require increased capacity for attorneys for commitments. But
Is that
all that aside,
2467?
I can't remember. I was trying to, that went to Ways and Means too, and the fiscal on that is
Yeah.
also gigantic. So I'm
Yep.
not, I don't know if that's going to go forward or not. But
Yeah.
there's that aside, like I was saying, I think it's a best practice for lawyers to be appointed earlier, and so we're working towards that in Lane County. Whether that passes or not, it's just a matter of whether or not my office can absorb that.
Right.
So I think one more like FTE lawyer in our contract, and we could cover it like as it exists right now. Obviously, I don't know if we would get that, but I don't think it's. I think Multnomah County is the place where they will need a dramatic expansion of capacity, and everywhere else, like we can probably figure out how to float it with the existing resources, or not a dramatic expansion of the existing resources.
So then as far as performance standards go, our standard would be, I don't know that we can change appointment practices in the performance standards, but we could write in something about how quickly someone needs to start working on the case once they're appointed.
I
Definitely.
think we could potentially like we could frame it around if your appointment occurs prior to the filing of the pre-commitment investigation report, then there are some additional tasks that some additional standards that might apply. If your appointment occurs after the pre-commitment investigation report is filed, perhaps some of those you just can no longer feasibly do, or write it such that, you know, the standard, this is the standard, but an exception to following the standard is you were not appointed until after the pre-commitment investigation report was filed.
I suppose the other thing we could do is write in commentary that the lawyer should work with local officials to assure appointment to cases at the earliest possible moment, or we can define when we would like ideally people to be appointed to cases.
I don't know that we can write a performance standard that requires people to work beyond the scope of the, like, to move towards system change. Like,
Not in the standard itself, but in commentary, and just say like, this is what we think is the future of the best case scenario, and we'd
That
like
makes
people
sense.
to be working toward that. I mean, it's not like you're not involved in your community, so you're not meeting your performance standards, but you know,
Right.
if you want to go above and beyond, this is what we think you should do.
I like your addition that doesn't necessarily have to be criminal background training, that maybe there are other attorneys with different backgrounds that could be equally proficient at representing civil commitment clients.
I think that's how we wrote the qualification standards, because it doesn't require that having a certain level of criminal background training is potentially sufficient, but not necessary. Let me see if I can find those again.
So I think it's familiar with the statutes, tried 3 cases to a jury or a bench, either civil, juvenile, or criminal. Knowledge of the civil commitment stuff, is observed 5 cases, start to finish, co-counseled 2 civil commitment cases, which resulted in a hearing or some kind of training, familiar with mental health, familiarity with resources available to those facing commitment and alternatives to commitment. So that's fairly open.
And I guess,
Which,
sorry, go ahead.
oh, I was to say, which then leaves us the question of how do we recruit more people into the practice who have those skills that we want, which is probably a bigger question for another day.
I think having like a sort of sanctioned training, like a day-long CLE every year, that's like a civil commitment boot camp or something like that, where we can like recruit in people who are interested. I mean, then we can all,
Mhm.
that would, I have always felt like that was sort of lacking in the CLE infrastructure to have specific training for civil commitment. So it could be, there could be half of the day is intro for people who are interested, and half
Yeah.
of the day is just sort of the civil commitment conference or something like that.
Yeah.
We have also identified a need for that kind of training. I don't know how quickly we are going to be able to do something like that, but it is definitely on our watch list.
Yeah. Well, and now that we've gotten the green light, well, I suppose I'm allowed to say stuff like this. Now that we've gotten the green light to start developing some trainings, we've got a week-long new attorney training that we're working on, and hopefully that'll go well and we can expand from there into more um, more trainings like that. And this is certainly something that would be on the list of things that we need.
So in response to your question number one, what it takes to be a good civil commitment attorney, I would say like there has to be a lot of well, time and flexibility in that person's schedule. I think one of the dangers of, traditionally having new criminal attorneys do it is that these are people who are overloaded, and yet, there's the expectation that they're going to be visiting this client at the hospital within 24 hours and, potentially interviewing not only their client, but maybe seeing if there need to be folks subpoenaed. And it's such a quick timeline that I think a lot of times what makes the good attorney is just the person who has the time and the resources to get out of the office and go see people and, not be handed this file the night before.
That was my experience at
Mhm.
UVPD. Was the call would go out who has their next day free to do this.
And so in Marion, we are one of the few counties that are we're appointed on day one, technically, and that's if the paperwork gets turned in on time. Sometimes the hospital messes up and we don't get the paperwork till day 3. But for us, in Marion County, our hearings are all on a particular day and time. So that's why we have assigned like particular attorneys to handle it, because we have our schedule cleared for that. I don't know if that's feasible though for other counties who have so few civil commitments that it's not helpful for their time to have a whole block set aside for something that may or may not happen. Whereas for us, that's a lot easier to do because we have more.
That's similar to how my office handles things. Like each lawyer on my team has an assigned civil commitment day that they know that they are responsible for when if the hearing is scheduled on that day. And we do a lot of postponements in my county, so people still have to have some degree of flexibility, but definitely for any of the counties that are remotely higher volume, I think maybe making it so that we're not like contracting out one case, one attorney, but like we're sort of thinking about how many cases are coming in on a day, or what's like a batch that could make it possible for a person to carve out time in their schedule to do that.
So maybe the standards are something like familiarity with county scheduling practices and able to maintain enough flexibility in their schedule to meet those practices, with the metrics being something like see clients within 24 hours of appointment,
I would just say like ability to prioritize these cases when they come up, like regardless of whatever hearing you're in. Because you do have, I mean, if you're going to do a good job at it, like you have to, like that's what you're doing for the next 3 days. So
Mhm.
it makes it easier to do that if people are able to schedule that time in. And like if you happen to not have a hearing on that week or whatever, then you fill it with other things. But understanding that if you do have a hearing, that's the only thing that you're doing.
Okay. I suspect we can craft some language around that to workshop. What else? So
I think established relationships or contact information at a minimum with these the treating facilities and kind of streamlined processes by which you can walk in and visit people without having to make appointments and that kind of stuff, avoiding the hassle. And then that familiarity with the contacts that you need in the community to, if you want the case to take a different path or be set over or consider diversion or guardianship or whatever the alternative is. Just having those available and knowledge about that, who to contact for what.
Yeah, I totally agree with that. I was just going to say that. And I think that's one thing where, because like some counties have the district attorneys, some counties have county counsel. So that's one area where it's important to not have the emphasis on just like criminal practice, because if the DA's office doesn't have the contract in your county, then like whatever it is that you do to negotiate a criminal case isn't going to apply to how you deal with your commitment cases.
okay. What about? Oh, sorry. Go ahead, Becca.
Oh, I was going to say, go on to the metrics of how we might monitor, um, I, one possibility is just outcomes, like how many civil commitment cases were set over, how many were resolved through full hearing, how many of them were diversion. Just my general sense is that a diversity of outcomes is a good indicator, whereas, if all of your cases are going the same route, that would be surprising.
Yes, I agree with that. And also, I think measuring how many cases are appealed is also a good way to think if people are really digging into the issues or if things are going kind of rote.
Yeah, and I suppose that's a good note about when we're talking about metrics. If we want to use something like appeals, we're not trying to craft metrics that are going to be 60% of your cases get appealed, so you're doing a bad job. Because, there are always those cases where, I don't know, you might have to appeal every ruling that a particular judge gives until the presiding judge moves them off the civil commitment docket. Not that Allison knows anything about that.
I think, yeah, I was going to say, I
But-
think like for civil commitments, more appeals is an indicator that the person is more engaged, just because
Yep.
at the trial level, the judges, like, they don't care if they get overturned. So
Yep.
like, that's an indicator that you are really looking out for.
There is a strong
But-
bias towards commit and get reversed.
Yes. I think
Point-
that
Point being,
civil,
sorry, Bailey. To finish that, the point being, what we're looking for when we're talking about metrics are things that are going to raise flags for us to look into. So it's not necessarily like this is bad. It's this is odd. why is this happening kind of situation.
So if you never appeal, then that would be a red
Yeah.
flag.
Yeah.
Like if there's a
agree with
county
that.
that has never had a commitment appeal, then like, why is that?
And it might be everything's fine and everything's working and you look into it and everything's okay, or it might be everything's horrible or anywhere in between. But
But
what we're
on the
looking
same
for with the metrics are
token,
something that we can use to figure that out. So go ahead, Bailey.
even if everything's fine, my typical practice is to submit a request for an appeal unless my client explicitly tells me not to. And the reason in civil commitment, and the reason for that is a lot of the time they're not able to articulate to me whether or not they want to. Even if I think there might not be an issue for review, I still refer it at least. And then the attorney that gets assigned can handle it from there in terms of, and I don't know if I'm giving the attorneys more work than they need, but my perspective on it is this is the population of people that are least able to, other than I guess like babies, are least able to articulate whether they want their cases appealed.
We don't want to
That's our
act as
practice
like
too.
a de facto waiver of appeal.
Right, exactly.
Yeah. Yeah. I think that's in our client's best interest for sure.
Plus, in my county, we're filing a omnibus motion in every single case that we are arguing. So every case that we're virtually everyone. I've had one client recently tell me I don't want to appeal. I'm like, okay, I'm not going to file it because that's what you want. We are trying a few issues, including whether a hold signed by a doctor needs to be notarized. We are filing on things that we've been discussing verbatim practices with the examiner. So there's issues that are going to be brought up that haven't been decided in the appellate court that are applicable to every single case, especially the practices of the investigators and the courts, or excuse me, not the investigators, the examiners and the courts having no issue with that, with how the examiners handle things. They just don't care.
Yeah, I
think-
think those kinds of issues, like, I don't know if there's a practical way to do that, but just thinking about like what are the live issues right now in civil commitment and what are the active edges where people are poking, and then just seeing like again as kind of a red flag, like are there counties or practice, I don't know, areas or particular attorneys even where none of these issues are ever raised. I don't know, that might be too nitpicky, but again, like, if something is a kind of active fermenting part of civil commitment law, it should be coming up in cases from all counties or all practitioners.
I think it's hard because we are all I started doing commitments 11 years ago. I started in Douglas County and then moved up to Lane County. And in the time that I've been doing civil commitments, it feels like we're sort of on the verge of big progress in civil commitments in terms of, I think in many counties, the practice for a long time has been to stipulate to most commitments, and they all have these kind of longstanding agreements with each other about like we don't rock the boat, and we all kind of know like who needs to be committed and who doesn't need to be committed, and the procedural protections are totally collapsed. But then also, I think recovery oriented and patient centered advocacy for commitment is important and can create some complications also as it interplays with the procedural issues, because our responsibilities to our client first of all, and so some of our clients are well enough to be able to identify like here's what I want and here's what my needs are, and so making sure that we are responsive to that, we are aware enough of the systems and the options for clients in that circumstance, and that we are first and foremost centering our clients' interests, whatever that is, and also being aware of the constitutional and procedural issues.
So that's actually something I was going to bring up, which is the idea of what to do with a client who lacks that capacity, since that is kind of the focus of the entire proceeding. I know, so there are current OSB, well, I'm not sure I would say current. There are OSB practice standards for civil commitments. I've always understood them to largely be oriented towards do what your client wants unless they can't convey it to you, in which case your duty is to protect their interests. That just not necessarily, well, maybe their best interests, but I never really understood it to be a best interests analysis. More of a protection of their constitutional rights focus.
Yeah.
So we could start with that as a bit of a framework. But beyond that, just wanting to double check, I assume that's also everybody's tack here as well, is primarily what your client wants goes, but default if they can't inform you of that. Like if you've got somebody who's catatonic, it's a protect their constitutional rights and statutory rights.
Yes, I think there's just some like gray areas in that in civil commitments. Like I know in some counties, they want to like transport clients from the hospital to the courthouse, like in restraints. And there's like, I mean, that there's obviously constitutional arguments associated with that, but like, luckily here, we don't do that. The judge goes to the hospital. But I've had situations where I'm like in the emergency room, holding room, like with a cell phone, so my client can be a part of the hearing. And I don't know that that's necessarily like strictly protecting their constitutional rights or strictly protecting their statutory rights, but that's client-centered advocacy, and that like rather than have them like dragged out of there and brought into the courthouse. And so I think like an emphasis on that's important.
I suspect there's going to be a preface or something along those lines to the bigger document that combines all of our performance standards that's going to talk about the importance of client-centered advocacy. But it doesn't hurt to mix it into the rest of the standards too.
Yeah, it's kind of a tough area to standardize just because client-centered advocacy in the situation looks so different for each person.
Yeah. And it can be one of those, the standard says to do this, except if it's better for your client not to do that, then don't do that. Okay.
Well,
So
and I think it's like it happens on such a short timeline. It's hard for, unless there's lawyers that like this is a huge part of what they do, it's hard to prioritize that in the first place. And then you get all of this institutional resistance to like, why are you asking for that? Why are you bothering us? Like, why are you raising this argument? And so I think we are going to hopefully be bringing in new practitioners that don't have that history, but we're also kind of doing a paradigm shift, I think, in creating these standards of just like making sure that people understand like that's the expectation. Like even if the judge is complaining, like you need to stand up for your client the same way that you would in any other situation.
Yeah, I would throw on there like, yeah, that's one of the metrics so that, like if a civil commitment attorney is doing a good job, they're probably pissing off the bench. There has to be a certain degree of institutional resistance. Like we tend to be the people who are educating the court about what they have to do in the hearing, about what they have to, offer this client, about how the process has to go. So I think there is kind of an educational component as well that goes into this role. necessarily.
So we want to include familiarity with developing practices of civil commitment law, and again, maybe in a comment, an encouragement to help develop the areas. And to make arguments that some may see as fringe, but are, of course, well based in law and for the benefit of your client.
And I think some of that knowledge can just be directly addressed in whatever training module is created.
Mm-hmm.
If, I think many of us, because I know that, we can, or OPDC can contact the appellate attorneys that handle these cases as well as us and gather, what are all of the burgeoning issues within the body of civil commitment law, because that's also going to differ for all of us for each county. We're all probably fighting a slightly different battle. Some of them are the same.
Mm-hmm.
And that way, if that's going to be part of the standards, there can be just a standardized method of us and educating folks who are coming into the practice on what those issues are.
Mm-hmm.
Is
there a way?
Is
there a way for people to keep up to date on what those issues are? Because I assume they change with
Chris O'Connor sends out
Chris
O'Connor sends out a kind of a what do you call it? Like every so often he sends out an email with a whole bunch
like
of
a bulletin.
Like an
Yeah,
appellate
like a
update or
bulletin.
something.
Yeah. Yeah, on both new cases that have come out as well as his pet projects that he's interested in people trying.
I have to step out now to go
Nice.
to my court appearance, but thank you all. I appreciate this conversation. Have a good day.
Good luck,
Thanks,
Allison.
Allison.
Thanks.
Yeah, that would be great if
Bailey,
that could be. Oh, go ahead.
I was just say, so Bailey, you had something else to say if we're done
I
with
was
the
curious.
update stuff.
Yeah, thank you. I was curious about how we measure the ability for someone to articulate how that they know how to, and in what order they would use the resources that are in the community to prepare a civil commitment hearing. Would they be required to name the people that they know they need to be in contact with frequently and their role? So like, I know that this is the county investigator, this is the director of the hospital that I work with most frequently, this is who I get records from? Or is it more of a just, I swear and affirm that I know how to get a hold of these people?
I think for our purposes, when we're writing this, it's just that they have to be familiar with those people. And then as far as enforcement or investigation goes, it's just if there's a problem, can you answer the question?
Okay.
I don't think there's anything that anybody's going to have to sign, or other than like the general, yes, I agree to comply with best practices.
Okay. Just curious.
There's no test at the end, except, the test of doing the job every day. So is there anything subject matter knowledge wise, or anything that you need to be prepared to do at hearings? I know in the criminal context, we're writing in like, you should ask for release hearings for all of your clients who are in custody, unless there's a real good reason not to. Anything along those lines that we need to look at including?
I mean, I assume familiarity with the DSM-5.
Yeah.
And the diagnostic criteria for committable mental health issues.
Mhm.
And also with intellectual and developmental disability, I know we've briefly touched on it previously that that's a pretty uncommon kind of commitment for most people. And I know that there have been a lot of efforts to move away from it, but we're still doing them. I literally just had a hearing yesterday. So I don't know how much OPDC wants to include familiarity with that process in civil commitment qualification, or I don't recall how much discussion we had if there should be separate tracks for each, because there's a lot of similarity, but the trick can be in the differences where you don't expect them. Even the standard for commitment is just slightly different after a change in the statutes in 2023.
We didn't
Mm.
we didn't differentiate between the types of commitment in the qualification standards other than extremely dangerous person.
That's right.
So-
Yeah, we've had a lot of conversation about that and teaming up with a criminal attorney if needed and that
Yep.
kind of thing. But with I don't know how much we want to focus on IDD, but there's a lot of differences, and it's the completely different grouping of people that you need to be familiar with. Different documents that are standardized that need to be familiarized. I don't know if we want to go into any of that or if that can just be just part of any training that's created.
I think we do want to cover it simply because we don't differentiate in qualifications, which means that if you're certified to do civil commitments, we are expecting you to be able to do both. So we need performance standards that cover both.
Okay. I mean, a
Anything
lot of
we
it
should-
is. Oh, go ahead.
Go ahead, Bailey. No, go ahead.
No, you go ahead.
I was gonna change the subject, but
Oh.
anything we should look at including as far as like use of experts, or anything like that, use of investigators.
I am pretty rarely doing that for either, and a lot of that is because of the time frame. My practice is a bit different from Allison in that we're not frequently asking for continuances, and a lot of that has to do with client preference, that oftentimes it's I don't want to be here anymore and I'm not going to override my client's desire to go down paths that ultimately are unlikely to be fruitful. I am usually able to gather what I need, but again, that's because I'm appointed on day one. I'm usually able to, if I have a concern that somebody is likely going to be being looked at for a hearing, I have the ability to start gathering that information from the hospital, getting phone numbers. And usually I'm the one making phone calls just because my investigators don't have time to, drop everything. And so I don't know if that's necessarily best practice, but that's what I'm typically doing. And then with regard to hiring experts, there's just absolutely no time to hire an expert unless it could be in a intellectual or developmental disability or in an extremely dangerous, but I haven't done that previously. I've hired an expert previously, actually, in intellectual disability. But that's it's not necessarily a standardized thing. It's not something I'm always consulting an expert on,
Okay.
because usually the expert I'm consulting on is someone who's being called by the state.
Okay. So anything else that we should be looking at, and Kevin and I can put this down and get a first draft ready. And we can still add or subtract or whatever we need. So don't feel like this is a speak now or for hold your peace situation.
I don't know if anyone wants to have a consideration for and this is hard to measure, but the ability to demonstrate knowledge of working with this population in a sense, I guess in a social sense, being able to successfully as best as we can, because obviously there's going to be people who are catatonic, but the ability to successfully work with someone who is in this position, either who is mentally ill or is intellectually disabled, the ability to work with that person and communicate information, get information from them in a way that is least harmful. Because this is a particularly vulnerable group of people frequently, and also notoriously among the most difficult to interview and advise. So I don't know if any of that should be included or if that's just something to think about.
No, I think that's a good thing to include.
Mm. Okay.
I'm not sure how
That's
we
what I
would go about putting it in, but we can come up with something, I'm sure, some kind of training or well, I mean, that's not a practice standard. I'm sure we could figure something out.
Yeah, it's something about like client communication, right? Like
Yeah.
you have to be able to build rapport or communicate with this population, which is going to look a lot different than other client representation.
Very, very, very different.
Mm. Okay.
I can't think of anything else besides that. Sounds
Yeah,
like a good
that's
list.
what I was thinking.
It's not in a way it's similar to representing kids, like the really, really small kids in dependency, but it's for different reasons.
Sometimes, yeah.
Mm. Okay. Well, this is as good a place as any to break for the day. So I'm gonna, unless anybody has any last words they want on the recording, I'm gonna cut it.
I've got one maybe it's not maybe this is something to wait for out the next one and have Allison break in or comment in on as well. So I'll hold off.
Okay.
Thanks.